Welcome to Pariksha, and today we will try to finalize this video. So we will continue from the till where we have left from the last video. So the first question come up is, what is the relevant date from infringement perspective? So as per section 11, the applicant shall have privilege if the patent was granted on the date of publication of application. Thus, in case of suit of infringement, the patent owner can claim damages from the patent date of publication of the patent application or date of infringement, whichever is earlier. And the suit for infringement can be filed only after patent is granted. You cannot file the suit before getting the grant of patent. Now, is it necessary to show working of a patent after grant? Under provision of section 146, every patentee or a license is required to furnish the information relating to working of patent, and same statement as to the extent to which patent invention has been worked. This must be submitted on Form 27 by 31st March every year. So by every year, end of every year, you have to submit furnish the details and information relating to working of patent, and this is to be submitted along with the Form 27 by the March 31st of each year. Now, international arrangements in patent act. So what is Budapest Treaty? This is an international treaty governing the deposition of microorganisms. Just remember the one liner here. Now, what are the modes of filing an application in foreign country? So, since there is no worldwide patent, the applicant has to file patent application in respective country separately to obtain the protection of his invention. So, under the Paris Convention for the protection of industrial property, it provides 12 months time to file a patent application in the member country from date of filing of earliest publication. And patent cooperation treaty, under PCT, we can file a single application in all the member countries. So PCT contracting states within 30 to 35 days from the priority date, we can file the application under PCT, and PCT enable extended time period. It also simplifies the procedure. Under PCT, there is also a simply procedure is too simple, and you can file a single application and get it covered in the all the number of participating PCT countries. So what is a PCT? What is a PCT treaty? So PCT is an international treaty with more than 150 contracting states. Now it is 157, which are bound with a certain formal requirement set out in treaty and regulation. And PCT make it possible to seek patent protection for an invention simultaneously in a large number of countries by filing a simple international application. And patent application is like a single patent application will be enough. And however, for granting of patent remains under the control of national or regional part of patent offices under the corresponding national phase. Now, what is the procedure of PCT? So for the procedure of PCT is to file an international application with regional office or national phase patent office, or directly with the International Bureau of WIPO, complying with the PCT formality requirements and fees. In India, PCT applications are filed at appropriate patent offices decided on the basis of territorial limits, and these are decided through Rule 4 of Indian Patent Act 1970. And for International Searching Authority, ISA identifies published patent document and technical literature which may have an influence on whether your invention is patentable, and establishes a written opinion on your invention on potential patentability. So while filing international application, you have to go through the ISA, which will help you in identifying the potential and relatable patent application. If there is no application related to your patent, then they will grant you patent. Like if your patent is already existing, then your patent will be seized. And Indian Patent Office Delhi branch performs the function of ISA. So you remember this one. On receipt of prescribed fee. Prescribed fee is specified in 5th Schedule of Patent Act 1970 as amended, and Patent Rule 2003 as amended. Now, international publication. So, after expiration of 18 months from earliest filing date, priority date, the content of your international application disclosed to the world. Now, in international preliminary examination, one of the ISA on request to carries out by additional patentability analysis using an amended version of your application. Indian Patent Office Delhi branch performs the function of ISA and IPEA as well. International preliminary examination on receipt of prescribed fee under fifth schedule of Patent Act as amended. Now, what are the right of the file an international patent application under PCT? So, PCT of international patent application may be filed by national or residential, like a member of a PCT contracting state. If there are several applicants named in the international application, only one of them needs to comply with the requirement. Like if they are like a team of global researchers who are working on a project, and only one of them is from the PCT member state, then then your patent is eligible for getting filed under the PCT. Can PCT file electronic? Yes, PCT can be filed in electronic through WIPO website. Now, in what language PCT application is filed? So, PCT is an international application in India shall be filed with the appropriate office in triplicate, either in English or Hindi. So even the PCT can be filed in Hindi. Remember this. And the request can be filled only in English. So the request for getting the PCT application should be in English only. So what are the costs associated with filing and processing of international application under PCT? So while filing under application under PCT, you will be charged international filing fee, a search fee which can vary from ISA chosen, and a small transactional fee which varies depending upon the receiving office. Refer fifth schedule of Part Act 1970 as amended in Patent Rule 2003 for the fee structure of international application. Now, is there PCT fee reduction of application under PCT? Like there is any fee reduction. So, for if you file electronically, there are fee reduction under application under PCT. Like in addition to encourage the use of PCT system by applicant from developing countries, fee reduction of 90% for certain fees, and including the international filing fees are available to natural person. So for developing country citizen, there is a 90% discount for filing certain fees like international filing fees to boost and to motivate them for filing more. Now, how long the PCT process take? So in most cases, up to an additional 18 months from the date of when you file your international patent application, or usually 30 months from filing date of initial patent application of which you claim priority before starting of national phase procedure with individual patent offices to fulfill the national requirement. Since also in the national phase, each patent office is responsible for examining your application in accordance with national or regional patent law. Regulation and practices. The time required for examination and grant of patent varies across the patent offices, like how much time they take to examine your patent. Now, what does it mean to claiming priority of an earlier patent application? Now, so the effect of claiming priority of an application is that patent shall not be invalidated by reason of any act accomplished by in the interval. So it simply means like if you file a provisional application before, then you are safe. Now your even the your invention is safe. You have already filed the patent application. So in meantime, after filing of your provisional specification, if anyone files the same application, their application will be seized. Now, international search. Can an applicant for patent Indian Patent Office and ISE or IPE of an international search applicant? So can applicant opt for Indian Patent Office? So yes, they can opt. Their like Indian Patent Office has their ISA and IPEA. And International Preliminary Examining Authority under the PCT started the functioning from 15 October 2003. Remember this date as well. Now, further, if the applicant chooses the Indian ISA, he gets an additional advantage to enter the expedite examination system, which ensures a grant of his application within 12 months. Now, which are the other officers which are appointed by the PCT to conduct searches? So there are following officers which conduct searches. I don't like sure if you should remember all these names or not, but you should remember because these are not all. So the PCT contracting states are international searching authorities, like they work as ISA, national officers of Australia, Austria, Brazil, Canada, China, Chile, Egypt, Finland, India, Israel, Japan, and Republic of Korea, and the Russian Federation, Space, Sweden, Ukraine, USA. The following regional offices and the European Patent Office and the Nordic Patent Institute, Norway. The availability of particular ISA to the national residents of a country is determined by the receiving office. So also like remember this thing, availability of national ISA to the receiving. It is like receiving office it determines the ISA where the international application was filed, and some receiving offices provide a choose of more than one competent ISA. If your receiving office is one of those, you can choose any one of them, taking into account different requirements relating to language fee etc. So what is PCT International Search? So PCT International Search is a high quality search of the relevant patent, document and other technical literature in those languages in which most patent applications are filed in Chinese, German, English, Japanese, and in certain cases French, Korean, Russian, and Spanish. So here Hindi is not available. Now, what is the value of international search report? So these reports enable you to evaluate your chance of obtaining patent in PCT contracting states. An international search report which is favorable, that is which the documents prior like cited would appear not to prevent the grant of patent, and it assists you in further processing of application in those countries in which you want to obtain the protection. For example, like if you it lists document which challenge the novelty and inventive step of your application or invention. You have the opportunity to amend the claims. So here if you directly like got a patent application which is already doing the work that you are doing, then they directly don't seize your application. They give you a chance to amend, like to make improvements, and if you make improvements and do something like better than them, then you there may be chances your application can be accepted. Or also they like ask you to distinguish your invention from the those that are existing. So will an international search can be carried out for all international application? So as a rule, and international search is carried out for all the international applications. And there are instances, however, where the ISA will not be able to carry out search. For example, where the international application relates to the subject matter which ISA is not required to search, or if the description, claims, or drawings are not sufficiently clear for it to carry out meaningful searches. In such cases, ISA will issue a declaration that no international search report will be issued. They doesn't like give you a reference number. They just give you a disclaimer like for your patent there is no international search report will be issued. Can third party access document contained in the file of international application? So and they can access only until the international publication made. Like they cannot access before the publication. Now we are just finishing with this. We are on page number 32. So how do I enter national fees? So this is for entering into national fees. You require to pay national fees, and in some cases filing a translation of your patent application. If you are filing into some countries, they Like they will ask you to give in their native language as well. These stuff must and also these stuff must be taken in relation to the majority of PCT. Like majority of PCT asks this, and before the end of 30th month from the priority date. So in all these should be done within the 30 days, 30 months. Sorry. For example, appointment of local agents for more general information of national fees entry can be found in PCT's applicant's guide and national fees. And the specific information concerning fee and national requirement can be found in national chapters for each PCT contracting state, the same guide. Now, what are the advantages of PCT? You have so PCT system has many advantages, some of which are like you have 18 months more if you have not used the PCT to reflect on the desirability of seeking protection in foreign countries, to appoint local patent agent in each foreign country and to prepare like translation. If your international application is in the form of prescribed by PCT, it cannot be rejected by formal grounds like by an any PCT contracting state or contracting patent office during the national phase or processing of application. Also, the international search report and written opinion contain important information about the potential patentability of invention, providing the strong basis of you for making international business decision about. Now, what is EPCT? EPCT is a WIPO online service that provides secure electronic access to the file of international applications under the PCT as maintained by International Bureau. So till here we have finished the all the frequently asked question of IP, and this PDF will be uploaded. Follow and like, share, subscribe us for like more information like this. Now we will come up with the important sections of the patent in the next videos. Thank you.